It's great to see everybody here. My name's Tom Brooke. I'm one of your organizers, actually, and I was working with Phil Jameson and Kanan here, and it's just awesome to see all you people here and coming from all over the world, and I'd just like to say thank you. This is an exciting event, and we said before, the amount of energy in this room, I mean, you can just tell it. Everybody just talking, corner you in a corner, and just really go through the number of ideas. And I think this is the type of place where things can really happen, and it could really have a reflection in the legal community, and hopefully we can go back and change our individual communities. So thank you very much for coming. This is the blockchain channel. Now we're going into a section this afternoon where we're going to look at more the technical areas or where we're hacking the law. And I think blockchain is really an area where we really are hacking the law, in effect. As Lawrence Lessig has famously said, code is law and law is code. And I think this is a place where that really happens. So I'm excited to go into this. I assume, I've been talking to the panel back and forth, I don't know what I can assume, and I'm not going to really ask for a show of hands. I assume everybody, since this is a legal tech group, you're all somewhat familiar with the blockchain, maybe you're not. The name of my presentation was, Dazza wanted me to change it, but I kept it as blockchain and smart contracts. And there's a lot of buzz and, hype about this area of the law, and it's going to take over the world, and everything's going to be on the blockchain. And hopefully, after you listen to our panel here, you'll be able to see a little bit more of the reality of the situation. And I love the term smart contracts. Casey Coleman with ERIS Industries famously says that what we're talking about is not really smart, and it's not really contracts. So it seems to fit perfectly with what we're going with. I think in its essence, though, and I am going to go into a very short introduction, a blockchain is somewhat akin to a database, but the key idea behind it is it's a distributed, which means whatever code you put on the blockchain is shared. It's like the old idea, if you remember Napster way back, if you were in the ideas of Napster, you put something on Napster and it goes through all of the computers in the network. The innovation with the blockchain was the ability to keep all those distributed computers in sync. And also, another thing, a blockchain provides a record, immutable record. What you put on the blockchain, you can always see it there. It promotes transparency. Those two things basically put together have created a revolution, and I think it's going to have a profound effect on law. I think it's going to change basically everything. And also, I think it's going to change computing. If you're running a distributed application on a blockchain now, it's probably not the most efficient thing, and I think we're just in the very early stages of the technology. And I said there's a lot of hype in this industry, but I think I'm really excited that we've gotten this panel together because we've got a group here that I believe really shows the reality, and a group that's really working in making the blockchain real. First, we got Mike Wheeler here. He's with Consensus. They're right here in Brooklyn, right around the corner. I don't know, I assume it's around the corner. I have no idea about Brooklyn. It may be 20 miles away. Brooklyn's a big place. Anyway, it's somewhere. It's a lot closer than Raleigh, North Carolina. He works with Consensus. Consensus, I think, at least from my view, is an Ethereum-based company. They really work with Ethereum. If you've heard of Bitcoin, which is probably the first big blockchain application, I think Ethereum's the next thing. It's a large distributed network. Consensus is doing a lot of the leading work. They've got some nice toolkits to make Ethereum easy to work with. They've got a lot of innovative applications. I believe there's even one involving power here in Brooklyn or something like that. And so that's one group that's not really a lot of hype. They're actually doing something. And from the academic side, we got Dazza Greenwood here. And I think you've heard of Dazza Greenwood. He's a legal hacker from way back. And he's with the MIT, is it Legal Computational Lab? law.mit.edu. And I guess he's our academic person here, but he's also got an amazing amount of ideas, and so he's going to give you a little bit of the academic view and a lot of ideas. And we've got two people here from ERIS Industries. Preston Byrne, who is a vice president in ERIS, maybe a co-founder too, I believe, and Nina Kilbride, who's a developer, lawyer at ERIS Industries. In ERIS Industries, I think niche is maybe a little bit different. They work on the blockchain. They don't have to work with Ethereum. Their idea is we've got platforms that'll work with your blockchain, whether it's Ethereum, Tendermint, Bitcoin, or whatever. They're just trying to be the toolkit with it. And they also, both Nina and Preston are lawyers. Casey Coleman, the founder and CEO of the company, is a lawyer. And I think Preston was saying they have 6 lawyers. I think ERIS is really the company that's working on putting the law on the blockchain and the law. They're working hard to find the way to make commercial contracts and things like that work. And also, they're the ones that are a little bit able, looking at an area where you have maybe what's permissioned blockchain, where you get your parties together and you use your own blockchain, don't necessarily depend on Ethereum. And what I'm going to do for just the presentation, I'm going to allow we're going to have 3 introductions beyond what I've said, where they can maybe talk about a good example of what they're doing, what their company is doing, or in the case of Dazza, what MIT is doing, and just a little bit of the more reality. And then we're going to go through about 3 general questions about the use of the blockchain and try to make it real. And we hope, I know we've got a limited time here, we hope we'll have a little bit of time left for some audience questions. So I'll turn it to Mike first.
All right, thanks. Yeah, so as mentioned, Michael Wheeler from Consensus here in Brooklyn. Consensus is a venture production firm focused on building decentralized applications, primarily on the Ethereum blockchain, but you know, blockchains in general. But yeah, it's founded by Joe Lubin, who was one of the founders of Ethereum. His mission is to build out kind of the building blocks that we can put together an ecosystem in the Ethereum blockchain to build with. Consensus is now about 100 people. It's growing quite rapidly. We have a couple of different pillars in the company. One is enterprise focus, so we do enterprise consulting. As you can imagine, all the banks, and we do financial services consulting, healthcare, music industry. All the different verticals are kind of exploratory right now, much in the same way 20 years ago. Companies came across this thing called the internet, and they said, okay, we need a strategy. We need to figure out how to implement the internet. That's very much where we are in the blockchain space today. Companies are trying to understand what this all means. So we've got that consulting side. Consensus also has products that we're building, some very core fundamental products like identity services, development environments, tools, blockchain explorers, things like that that are really core wallets that are core features that you need to kind of construct more rich applications. So we're kind of really at the beginning stages of building out that ecosystem. That's me.
Great. Thank you. I'm Dazza Greenwood, and I run law.mit.edu, and I think I'm on the panel to talk about some of the research that we've been pursuing. MIT's been a university that I think shown very good leadership and support for Bitcoin and for blockchain technologies because of what they represent and the capabilities they have, and how once we tune the technology to business and legal requirements and expectations, I think they could be quite powerful. They could transform. So part of what we're exploring is a little bit over the horizon. And with respect to law, one project we just launched a few days ago is called lawchain.org. And that is a prototyping effort to test whether blockchain's immutable record capability can be used for legal requirements that basically currently we would meet by using Iron Mountain or an archivist business in some way, or potentially if their business has many different locations, you might distribute copies of the records. All not bad, best we could do. But one of the great things that blockchain does and is that there's a copy of the entire ledger of a blockchain in every running instance. It's massively distributed, and because the ledger's text file, it's actually not that big to have a copy of every transaction downloaded along with the code. not as big as some movies I've downloaded. And so we're looking at using, one thing would be statutes. So many people here, I know you heard from Ben Kalos and others, are interested in putting statutes and regulations online, the authoritative version. However, to have the authoritative version online requires the ability to demonstrate to a high degree of confidence that that record is the record that was enacted by the legislature or the agency. Legal publishers are good at that. They have procedures, and they've been able to do that. And currently, that's really the state of art. So the laws that you see on websites for cities, states, federal agencies, there's always a disclaimer, this is not the authoritative record. There may be errors. You cannot enter it into evidence as part of litigating a case. It's just not real. You can't depend upon it. That's not good enough. And so one thing that we want to test is, well, could we put called a hash, basically a digest of the record of a law or an amendment to a law onto a blockchain? And we think the answer is yes. And now what you have is a publicly verifiable, global, archived system where anybody, anywhere could demonstrate at no cost that a given record, say on an agency website, is the statute regulating this or that thing as enacted at that time. In Vermont, people think this is such a neat function that they've changed the rules of evidence now by statute. So that self-authenticating, information on a blockchain can be self-authenticating now, as similar to, I don't know, like the weather on a New York Times report or that type of thing. So that's one thing that we're going to look at, and that if that's successful, you can imagine all of the law that's authoritative being accessible at REST interfaces. It could feed into apps and services, very findable. It also creates a common format for analytics and for other workflow. The other thing I'll say quickly is we're looking at using the blockchain as a ledger for entities that could be completely automated. So we're working on an automated financial institution prototype now for credit unions, where we think that the shared ledger that's required by federal regulators as part of their charter could be in the form of a blockchain, and it could be a shared service across credit union industries, which is part of the ways that they operate now. That seems to have a lot of promise. So we think blockchain has a lot of good capabilities, and it's worth exploring. And we'd very much like to invite everybody in legal hackers that's interested in doing prototypes or in joining open source projects, which is the only kind we do at law.mit.edu, to come to our site and to sign up and hack with us, hack the law. Thanks.
Hi, so I'm a lawyer. My name is Preston, and I'm the COO of ERIS Industries. And so what we did is we looked at, very briefly, when you're running an application of any kind, ultimately what happens is there's a person sitting at a computer looking at an interface in a web browser, and that is the same as all the 2.0, all the 2.0 blockchain applications that are being built now. So the question is, how are they different? And the answer is because you have a database which is doing the same thing in multiple different places at once without running on anyone's metal. And then everything from there, you can just go and say, all right, well, what do we want to use this sort of thing for? So we looked at it and we said, well, that sounds a lot like, for anyone who's a transactional lawyer, that sounds a lot like a deal. That sounds a lot like what happens when you sign a bunch of contracts. Those then govern things that are supposed to happen, over the course of the life cycle of a relationship. So that's what we do. And basically the platform, we're quite agnostic. There are many different blockchain designs out there. They have many different features. They have many different characteristics. And our stuff, which is all open source, the objective is to allow a developer who is a lawyer or anybody else to take this technology and then harness it and then apply it to solve a business process issue. I'm not going to go into that too deeply because that is the expertise of our head of, not just a mere developer, but our head of legal engineering. I think we're the only company, I think we're the only software company in the world that has a legal engineering department, and that's Nina Kilbride, so I'm going to hand that over.
Thanks, Preston. I'm Nina Kilbride. I'm also from the great town of Raleigh, and when I discovered blockchain, what I saw in it was evidence. I've spent 18 years as a commercial litigator, and as Preston said, I saw deals. I saw the building blocks of deals, how we put them together after deconstructing the relationships that go into a deal. So my job is to figure out how to take this new tool that really did not exist before, a reliable way to give us an interoperable system and build workable commercial and legal relationships with it. And that requires us working in a team of developers and legal minds who can understand not only how are we going to make a technical application work, but how we are going to understand all of the context around it, issue spotting, and make sure that your use case is fit for purpose. And from that, we have the ability to build a lot of new and reimagined kinds of legal tools. And when I'm talking about blockchain potential to lawyers who aren't technical at all, when I try to explain the import of the this new invention of blockchain technology. I heard somebody else talking today about we're opening up the West. I see that same thing. What we are looking for is an interoperable set of rules that can go across jurisdictions. And who can do that? Legal engineers. My favorite example is from North Carolina General Statutes, Volume 6, that has rattled around in my car for 20 years, and that's the UCC, an algebraic breaking down of commercial systems and rules, reflecting arm's length best practices. How can we build like that? And that's what we're working on here at ERIS.
And you can just hang on. Is this mic working? Yes. Okay, supposedly it is working. Oh, so I just have to yell? I'm not going to say much, so I can just yell. Now we're going to switch, and you guys can pass the microphone around wherever you want to, and I wanted to address a few subjects. And the first one is just a basic question, a real simple one, is what is a blockchain good for? I've heard deals that it could be good with deals, or it could be good for forming a credit union. What characteristic, if you got a legal situation or even a societal situation, would a blockchain be effective or useful for? And maybe even more enlightening, what just wouldn't work on a blockchain? Should I put my wheel on the blockchain, or you know?
I'll give the really boring. I'll give the really boring answer, which is that I was talking to a potential customer the other day, and we were talking about some financial process, some instrument. And the conversation basically it didn't require too much pitching. It was like, look, this is what's going to happen. They were very much at the beginning of their journey of mapping out what use cases they have and blah, blah, blah. And I said, look, this is how it's going to pan out. You and I know this. You're going to spend 3 months working with a consultant. They're going to take an internal business process that you have, and you're going to show all of the events and all of the message passing and everything that needs to happen. And then what you're going to do is you're going to take a blockchain, you're going to put it in it, and then the process of reconciling and message passing is going to be removed. And so you will, instead of someone saying, oh, I'm sending a buy order, and then I'm getting a confirmation back that the buy order has been received, and then I want to confirm that I've received that confirmation, at which point settlement will occur, and blah, 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 blah. No, that doesn't happen. So what you do is you take these 20 steps of process, and then you collapse it into 4. And so that's pretty much, and then you have an IT infrastructure where you can stand it up and face it to whatever other APIs your bank or other institution or government are using, so you can have it be a payment trigger. So blockchains are reconciliation engines. Bitcoin, fundamentally, I think the only consistent answer for what it is a reconciliation and settlement engine. It's a robot, or not a robot, but an automaton, which does that and collapses that process. So that's my view. It's boring, commercial, not inspirational.
I'm inspired, however. I mean, if you've ever done any payment network or payment network stuff where you dealt with reconciliation and settlement at the end of a day, you would find that inspirational. It's painful and just what a waste. So I think if you looked at what are the underlying capabilities that that make possible the reconciliation and settlement, like collapse to like a few steps, what it is basically is you've got a single unified record that people can look at, so you don't have to futz around between all the different players, showing what do you was it, how much do I owe you, how much do you owe me, or what were the transactions, and then somehow conforming those things. because you've got one record. That's great. So another thing that's good for is when you only have one party that's trying to communicate to another party. So you're not even reconciling, and that happens in the law all the time with constructive notice. And so if you look at the time when we require legal notices to go out, but you don't necessarily know the address of the other party, or they're, avoiding you, you can put them, or if you're trying to make it so it's fair and everyone can know it, like a procurement, or if there's a safety thing, like a car recall. There's lots of times when we can't do personal notice, but we need legal notice. We're going to bulldoze a house, we're going to refab the city. So right now we put in newspapers of general circulation as though that is real anymore. It is not. And blockchain, by contrast, because of what I mentioned before, the massively distributed nature of the architecture of how the blockchain technologies work, is a perfect place where you can not just evidence a transaction, but evidence a notice of, for example, a procurement. So I've been told, Professor Lupino and I, and Jonathan Askin a few moments ago, that he'll be having something like a hackathon in October for the New York City record. That's the record of all procurement and things like that. Every city has such a thing, every state. There's the Federal Register. This is a common need in the public and the private sectors to be able to put others on notice of things at large in a public way. The publicly verifiable capability of the massively distributed global and freely available blockchain is the perfect match for this core eternal legal requirement and business capability. So there's a second.
Yeah, and I think so. What is a blockchain useful for is a great question. I think the hype machine about blockchain now is kind of at full volume. So you got a lot of people walking around with the blockchain hammer trying to smash every problem with it. The truth is, as Daz just said, it's the very nature of distributed ledger technology means that it's very computationally expensive and slow. But the trade-off of that is it's immutable. It's unhackable. You can't take it down. It's completely distributed. So you have to think about it in those terms. I think abstracting what is a reason why you would go for a blockchain. I think about if you have two parties who each have their own goals, but they want to work together, but they don't share any infrastructure. Blockchain becomes that shared infrastructure. The two parties can maintain their own goals and work together and not have to trust each other. I think that's... You can always fork it, right?
So I would add to that one thing that I know blockchains are not good for, and that is non-deterministic discretion. A lot of times in contracts, we want to bake in the ability to humanly make up our mind later. That's not really one of our more appropriate applications. And so the idea that sometimes in the hype machine will tell us blockchain is going to take over the world, we as lawyers know that there are a number of things that are not if-then conditions. But then we have that gigantic swath of legal commerce in the middle that really does ideally run on if-then and documentary conditions. And those are the ones that are most appropriate for blockchain applications.
There's one other, it may not, I think this should be tested, but it may not be good for just a single internal enterprise system. There may be much more performant ways, and there just may not be requirements that it satisfies when you're doing IT or other processes in one individual system. When you start networking across multiple systems, even in a payment network where you're doing reconciliation and settlement, where people do know each other, that's hard enough, and it could be good. And when you're in what you were talking about, parties that may not trust each other, maybe in open commerce, UCC, and other trade or communications networks where by design people don't already know each other, and yet we want a common method to trade, to communicate, to transact potentially, something or another. That seems to be the sweet spot. But even that should be tested. I mean, maybe it is still better for lots of individual internal systems if you even just want to unwind what happened later, perhaps. But anyway, that's the current wisdom, is if you're an individual, single node that doesn't connect with anything else, that's not the right fit.
Unless you're trying to prevent a SQL injection attack, in which sense it's a great fit.
Thank you, Preston. Yeah, go ahead.
It's about the payments and the reconciliation. What about then, say, mobile payments in Africa, where people are sending remittances, cross-borders, or using their mobile phones to make payments, which is US miles away? Would it be a good thing to use there?
Yes,
Repeat the question. Yes, no.
The question was, would blockchain be good in, say, underbanked or unbanked places, say, like in developing nations, potentially, where right now there's some mobile phone uptake of, and it seems to be a desire. I think the answer is yes, it appears that way. It hasn't yet been demonstrated, but at MIT we've got something called the Digital Currency Initiative, which is working very closely. There's a group going out, I might go with them in August to Kenya, doing some microfinance, and there's a lot going on in Mexico right now, and there's a bunch of systems that we're collaborating with to see, to test whether or not we can reduce the cost and extend the reach, and also to de-risk it more. But the one thing that's great about it is you can encapsulate any type of value you want. So you could say this is 1 peso or $1, €1, or other things. So when you're looking at some of these other systems that have loyalty points or have a type of currency between like the agriculture and the something else, and where they're trading points back and forth, it's a really good fit for those types of economies. Time banks is another in developing nations where I'm starting to prototype something where you put an hour in, you get an hour out. There's some great communities where that's very, very efficient, as a matter of fact. And right now they're using like Excel at best in some of the ones I've seen. And then there's inevitable disputes, among people of goodwill that maybe aren't great at record keeping in these more informal systems, the informal economy. So encapsulating the value in a publicly verifiable way could maybe let people really come ever that much closer to their potential. So they don't have to think about that.
Okay, okay, I'm sorry.
Briefly, in the short term, if you think about the use in sort of debt instruments, I can imagine state law, like all the law school exams, sort of registration, property law things around first and second mortgages and things like that. What do you see sort of maybe in the U.S. context? Is this entering, actual sort of traditional legal practice in short term?
Nina, you're clapping your hands.
That's me.
That or bearer bond on the other, sort of whether or not a public or private chain is required by the law.
Would you repeat the question, because I'm not sure I understand now.
So if we want to replace, for example, public registration and that process with a sort of, the whole blockchain sort of model, I can imagine a state law mortgage instrument being registered with blockchain title. That debt instrument then is authoritatively, sort of registered so as through that blockchain title that would be publicly disclosed. But you can imagine with private ones, it looks more like a sort of a bearer bond sort of problem where that sort of anonymity and sort of chain of title might be more of a question under traditional law. I don't know, not an area of practice, but I'm just thinking bearer bonds are bad in the U.S. is what I thought.
Well, again, if I understand your question, yes, I see there's every bit of the potential to interface with public registries, things like liens on title that go on to a blockchain for our chain of title and authority. As to whether we get into questions like Dazza was talking about, as to whether you want to have your blockchain configured in certain ways for certain use cases. And I really think there isn't a big broad answer to that, and there's going to be a multitude of chains with a multitude of kinds of different rules because they have a multitude of evidentiary needs. Does that answer your question?
If I have a blockchain registered mortgage for that title process, is that 5 years out? Is it 50 years out? Is it 20 years out?
That's 12 months out.
In Virginia.
That's 12 months out.
12 months out.
So you remember, these things are not, people talk about blockchains in the abstract, and it's super fucking annoying. So people talk about blockchains in the abstract, and it's super fucking annoying. I just wanted to repeat it verbatim. So just to get, as a matter of record. And remember, these things are applications. They're built to serve a purpose for someone. So if you wanted to have a blockchain mortgage, It wouldn't be, you don't have to structure it like Bitcoin where suddenly it becomes a bearer instrument. You could turn around and say this is a process automation tool for the town, for the county of Middlesex, Connecticut, which is designed to automate the process of title searching and reduce the time and cost from $2,000 in a week to 5 seconds and free. So, but again, then you're just like, okay, well, what's the code for this application? How do we write it? How do we optimize it? So it's not you're not pinned down into the Bitcoin style way of looking at the world, which I think is horribly corrupt and doesn't really work in mainstream commerce. You are totally at liberty to express, you could, in the Solidity contract language, anything that you can write. So you can make it totally, you can put in room for human discretion, you can have registered, certificated, whatever. And then it's just a question of what the docs say and whether the blockchain marries up to the docs.
There's something else too, very quickly. So you said in Virginia at the end, and the question for those in TV land in the future was, could this be appropriate for bearer instruments, for example, or other places where you need a public registration of, and I think the answer also is yes. And then you said 5 years out, 10 years out, and that's the part I wanted to address, which is, well, you could make it 12 months out. You guy sitting in the chair right there looking at me who asked the question. In Virginia, by talking to the Division of Banks and talking to Tim that did help with the statute down there that you've got for electronic notarizations and so forth. There's people with names that could apply the requirements for the registrations in that state to a pilot and could incorporate it into a bill. And there's a lot you can do just by private agreement. In fact, by a executive order or by a Division of Banks indicating under the statute they're interpreting ABC implementations as compliant now, for example. So I'd say by taking some initiative, what the folks from ERIS were getting at when they were saying you can apply the technology is it's not like it's a robot that has a roadmap about when it will give us some functions. It's a very supple type of capability that you can apply with software programming in different ways, but you need the authoritative parties to come together to agree and then to actually hack that thing. And so I would encourage you to do, if people were into it and they wanted to apply the tool that way, they could happen quickly, I think.
I think I'm getting the time signal, and we're about getting near to time to wrap up, and I'd like to thank all of you for appearing. And I assume most everybody will be around later this afternoon if you want to pin anybody down and ask any further questions. It's a complicated subject, and it's hard to cover in a short amount of time, and all of us up here could probably spend days talking about this, probably tell you more than you wanted to know. Thank you very much. Thank all four of you.
Well, I'm Larry Bridgesmith, and I'm associated with Vanderbilt School of Law, but don't make the mistake of calling me an academic. I'm not, I can't, I won't. I'm more of a pracademic, which means I masquerade as an academic. And as a result, I think this is a topic that I've found very, very intriguing over time, but I'm not an in-depth expert in AI. The reason that I've found this fascinating is because it's everywhere. So every good presentation needs a subtitle. So one of mine choices was, how far will Pokemon go? And most importantly, have you caught your hyena yet? Because this last April, we had a conference at the Vanderbilt Law School, and we involved Richard Susskind, who came to talk to us. As you know, his most recent work with his son Daniel is on how the professions are being transformed. We had about 100 people in attendance. It was a fascinating day. Not only did we hear from Richard what it might be, we began to hear from people who are doing, not just talking, about artificial intelligence. So we were fortunate to have Andrew Arruda from Ross, and Andy Dawes from Riverview Law, and Dan Katz from Chicago Kent. All of the folks that are not just theorizing, but actually making a big difference. And we lawyers, which I noticed most of us stood up identifying ourselves as lawyers, we aren't scientists in many things, but we have mastered the science of semantics. And so what I discovered over the course of putting this program together in April, and then those who participated in it, was no one can define the term, but everybody's arguing about what it means. And so what I would like to do today is not go deep and answer those questions. Let's let the semanticians continue to carry on that debate. But more importantly for us, I would like for us to begin to think creatively about how any of these developments in technology that have an intelligence connected to them can be of benefit in the world of legal hacking. And a couple of disclaimers that go along with that. I will mention a number of companies. I have no economic interest in any of them. And the second disclaimer related to that is, had I had the benefit of the presentations to this moment in time, I probably would have included more logos than I have included. So this is not intended to be a definitive survey of the world, but that's where you come in. Because I will get through my remarks rather quickly, and then I would like for you to augment the presentation with a real-time poll of what we can do with what's taking place in what is called AI as it relates to the world of legal hacking. So we have to start with a test. You may have seen this circulating in the Twittersphere this past week, but I think it's a great way to start. For example, the world who is uninformed on either AI or economics believe that the world is coming to an end and the machines will take all of our jobs, and it's the end of the world. Well, those who are highly informed about AI but less so about economics see another end result, and that is that it's going to take all the jobs, but we're facing a future of poverty and unemployment. So that's one of those hypes that we hear. I would take it even further than that by some. For example, Peter Diamandis believes that the end result here is that we'll all live a life of leisure, because once singularity occurs, when the computer brain is equivalent to the human brain, we won't have to work anymore. So we can just live a life of leisure and pursue those higher human pursuits. Well, that's on the far extreme. But if you're an economist, you're looking at AI as the equivalent to a new industrial revolution, and soon every interface will be a chatbot. But when you have some degree of expertise in both, you see it's not quite that exotic. And what I would argue is, even though it may take a while for AI to reach its potential, I do believe that there's a lot going on that we can take advantage of if we just open our collective minds to doing so. We as lawyers, and probably we as humans, much prefer the silver bullet than to doing any legitimate work. There's not a silver bullet for artificial intelligence and the law, but there are enormous amounts of ammunition. So in order to just give us a framework for conversation, I'm going to borrow from Appcessories, which is a organization that does analysis of applications. And what they've given us is a great infographic that appeared about a week or two ago. And they've divided up this world of artificial intelligence into 13 categories, which I'll introduce briefly. And what I'm asking you to do is to think about, with respect to each of these categories, not did they get it right, but assuming that they did, what possible applications might these technologies do for us in the world of legal hacking? So the first of the general kinds of AI or artificial intelligence is deep learning or machine learning. And you can find people who will argue that the two should never be used in the same sentence. And I'm not going to go deep into any of those. Kathryn, who will follow me, will give us much more detail about the deep learning, machine learning work that they are doing. But we know FastForwardLabs, with which Kathryn is associated, is one of those general deep learning, machine learning organizations, as is IBM Watson. But on the right hand of each of these slides, if I know of a particular legal application, I want to highlight it just to generate your thinking about, are there others? For example, did you know, I didn't until recently, that IBM Watson associates with approved universities and provides access to Watson for hackathons. If you didn't know that, you need to know that so that you can associate with one of those approved universities. Fortunately, Vanderbilt is one of those universities, and we will definitely bring in Watson into our hackathon ethosphere. So you get the idea here. The second kind of category is a particular application of deep learning. So industry specific. And there are a number that we can think of. I don't know if you've heard of introspection, but it's a deep learning application that is intended to look at the wide and deep data within an organization and predictively highlight potential legal violations before they occur and advise and prevent them from occurring. Or you probably do know about premonition, which is one that's looking into the track record, if you will, for those of us lawyers who ever want to get hired. How successful have any of us been before a particular jurisdiction? But you also know Ross, and you also may know of Clause, which is a new startup here locally, which is in that smart contract. They prefer calling it the intelligent contract space of using blockchain type technology to create a living contract that, based upon an organization's data as implementation of the contract terms begins, is constantly adjusting to the state of the relationship. Well, I pose those to simply say, I've had conversations with the CEOs of Ross and Clause, and they are both very interested in partnering with the legal Hackesphere, so that those are two companies that we can begin to have conversations with about how at your next legal hackathon, they could very well be a part of the resources available to you. And I would suggest far more of these will be willing to do so if approached. I would assume ERIS would entertain that. I'm not trying to put them in that box, but think about it. It's the way in which most legal technology has really acquired bandwidth. So another category is natural language processing, and that's more akin to e-discovery, with which we are very familiar in the legal space. Relativity being one of the biggest use cases of e-discovery. Natural language processing, but next LP is another. But there are probably hundreds of icons that we could put on that side of the equation. And then there's natural language processing in speech recognition. Of course, we know how Siri works, and we know how Amazon Echo works if we've just watched the advertisement. They take our speech, and then they convert it into language requests or commands. I don't know, and there may be some legal applications that should be on the right side of that slide. But that's where you come in. Help us fill in the blanks. And then there's computer vision image recognition general. In other words, facial recognition coming from static photography to help identify individuals. Well, that's broadly a part of the work that IBM Analytics does. And in general terms, I'm not yet familiar with any legal applications, but there are some in the specific application space, because CopLink, I2CopLink, and ViView take that identification capacity and look for patterns in criminal identification from either officer-mounted cameras or the surveillance cameras that they seek data access to. So that's an application. I have no idea if that has any value in any of your hackathon activities. It might. And we, of course, know of we and gesture control. And I'm thinking that in things like gesture control and another category in a few moments, there will be plenty of possibilities for application in the area of physical disability. Where can we bring this technology into healthcare for those who need the computer-assisted technology available to them? And of course, personal virtual assistants or virtual personal assistants. Kim, which is a Riverview Law AI technology, is likewise one with whom I had conversation, and they're prepared to jump into this pool with us and create an application sandbox for legal hacking. So that, again, for non-commercial purposes, these are AI types technologies that we could be more expansively using in our hackathon ethosphere. And smart robots, most notably in the manufacturing world, but Neotologic and HiQ claim that they've brought that technology into law. And on the 27th of July, you can attend a webinar in which they introduce their smart robot, their lawyer robot. So again, are we using these capabilities to their best advantage? And we know, of course, the power of recommendation engines and collaborative filtering through Amazon and Pandora liking our likes and then giving us what we like. Again, there could very well be an application for us. And context-aware computing, like the iWatch, who knows where you are and where it is in relationship to your eyes, as well as Waze technologies. Are there legal applications here too? I think of applications for physical disabilities that could very well prove beneficial. And then the last category that Accessories identifies is speech-to-speech translation. And again, enormous potential applications here, where one language can be spoken and then translated into 58 or more different languages in real time. So are we thinking broadly enough about the way in which these technology applications could help us in the legal Hackesphere? Video automatic content recognition is the last one, and it takes, instead of static photographs, video photographs and looks for patterns in terms of brand identity and individuals, or even copying scenes that might be very similar to a scene in another movie. Media Rebel is a legal application that takes video deposition testimony and then compares it to the research that's been done on indicators of deception. It's not evidence, probably will never become evidence, but wouldn't it be great if you're taking the deposition of someone and you begin to see where they are less trustworthy on certain topics than on others? Certainly could be a huge benefit. So all of these things in the ethosphere of AI, according to Accessories, represent a very robust number of companies. And you'll see each of these in turn. I will upload this entire slide deck with your suggestions so that you can do your own analysis. But the most critically configured area is machine learning applications. So that's a place in which there are about 260 companies already operating that we might want to know about and bring them into our world. All the way down to natural language processing, which is next, and at the very end, the smallest number are video content recognition. And then also, what is the amount of funding by these categories? Yesterday in the Corporate Counsel Law Tech Division, the American Lawyer publication, there was an article involving Bob Ambrosia's view of legal tech, and I think he's got it right. And that is that over the course of time, we're going to see infinitely configurable legal tech applications. A particular lawyer will know that there is a platform that is most critical for their use, but by virtue of integration and the exchange of data through API interfaces, they're going to configure their dashboard to reflect the best use and the best applications that are unique for themselves. So, according to Bob, there's now a $3 billion legal tech spend annually. So there's an enormous amount of money and development flowing into this world. We just need to begin to capture it. So that's where I would like to get you involved. If you'd take out your smartphones and help us add to this, this is a poll which you can either use by text or by tweet. Those are the easiest ways. If you text a suggestion of a particular application, whether it's by brand or just by concept, how can we expand the legal Hackesphere universe by thinking more expansively about how these technologies might be brought to bear? So if you text 96172 and your message, to 37607, we'll begin to capture your input. If you tweet to @poll96172 and text your message. And I'll give this a few minutes to populate, and then if we wish to discuss anything that you see, we can do that. How much time do we have left, Phil or Jameson? We're about time, okay. Curious to know more, okay, good. Let's keep the conversation going. Yeah. Was it something that you didn't want to be seen? Well, join us, have this conversation. Let's add to the picture before we turn this over, and let's see what your thoughts are about how to broaden our awareness and application of artificial intelligence. Any suggestions? Any tech tools that you're aware of?
So Larry, is it poll? It's poll plus the number.
Yes.
That's the whole.
Yep. It's not taking? If you're online, you can go to pollev.com, and that's more cumbersome. It's easier to text or to tweet. Yep. Just tweet to @poll96172 and then your comment. And if you're concerned and you want to pull it back, you can. And there are no limit to the number of comments you want to add. And it's anonymous. I'll not know, nor will anyone, who said what. For example, I would think that the technology that allows geo-tracking, which Pokemon certainly does, would be extremely valuable in resource location. Could we combine the two? How do I find that resource that I need in a particular legal hack? Where is it located, and how do I locate it? So, did we? Oh well. You keep texting, you keep posting, and I'll upload your results so that you can have the benefit of them. Thank you so much.
Cool. All right, cool. Actually, I guess before I start, so I come to this world, my doctorate is in literature and math, and I entered into this world, my first job after I left, a doctorate in comparative literature, I thought I could be a taxi driver or a professor. So I was fortunate enough to get a job at a legal software company focusing mostly on large law. So I'm very familiar with the way in which large law applies tech or fails to apply technology. And I think one of the things that's interesting about thinking about AI in law is that, at least in this large corporate space, historically, or up to a couple of years ago, lawyers weren't totally enthusiastic about technology because most technology in law firms was back office. It enabled lawyers to practice the way they always had practiced. So it made things go faster, you could find efficiencies, et cetera. This stuff is changing things because it can practice alongside lawyers. It's shifting the way in which law can be practiced, and therefore shifting also the economics of the way large law firms will work if this whole revolution actually does take place. So I think I notice that, for example, when I talked about information security, general counsels would sit there with their eyes closed, and when we talk about this, they open up. So it really is an exciting moment. So FastForwardLabs, went from that world. I now work for a machine learning research and advising company. So in a nutshell, we help companies innovate using data and machine learning. How do we do that? So we have a research side and an advising side. On the research side, every quarter we pick out an algorithm that we're interested in because we think that it's just today becoming possible to build products using these techniques that work. So they could be reliable in a commercial enterprise setting or in a startup setting. So they're going from academia into the real world. And we start by building out prototypes. So we're not market analysts, we're geeks, we're techies. We start by building a prototype to show what kind of applications you could build using these general math techniques. And then we write reports that explain what they are, who's working on it, what you can do with them, and then actually have a how-to guide for technologists that teach you how to build them. So what data do you need? How long does it take to train? How do you maintain them? what mistakes did we make when we built them, right, so that our customers don't make those mistakes. And then the third side is we actually help people take our prototypes and put them into practice and implement them. So there's sort of the one stage, which is writing some code in Python or R, and it's not quite ready for prime time, and we're a small team, there's 10 of us, and we depend upon much larger enterprise organizations to put it into production, use all of the resources that they have, and also help learn where is this actually viable and impactful, right? How do banks want to use it? How do insurance companies want to use it? We don't have any law firm customers, but that would be cool if we did. How do media companies want to use it, et cetera? So in this talk, I'm going to talk about 2 particular applications, and then I'm also going to talk about what I consider to be the core obstacles to adoption. There's a lot of people here from Raleigh. I believe that North Carolina, at least based upon the case law in 2014 and 15, is really going to be like the state where this gets hashed out. Because the most interesting, all of the interesting fights against LegalZoom, Lola versus SCADA, and I'll talk about that, it's all North Carolina law, so yay. So my friend Tim Huang, he's at Data and Society now. He used to run this little stunt in San Francisco called Robot, and Huang, helping people imagine a law firm where 2 of the core partners were servers and the third was Tim working together with these servers. And he talks about what he calls the uncertainty loop. So why does legal tech suck? Legal tech sucks because there's legal uncertainty in the UPL doctrine. So, what qualifies as the practice of law? I think it's a super cool philosophical question that I pose to my law school students when I teach, to have them think through how new technologies are forcing us to revisit, what is a legal judgment? Does it require going from general statutes down to particular cases or not, right, et cetera? So because there's uncertainty, there's risks for entrepreneurs because this might not work. You could have class action lawsuits against you when a lot of frustrated solo practitioners say, screw that, I need to save my livelihood. Which means VCs say, why would we invest in your company if it's not going to be one of those billion-dollar unicorns like Scott talked about? Which means the tools don't have enough funding to be developed well to go into production, which means they don't get adopted, which means there's no motivation to actually modify the stat suits to try to sort of shift this dynamic. So I like that concept, and it's something that I'll talk about throughout my talk. Okay, so digging into what these things are. So first project we did at my company was on natural language generation. This is not super smart chatbots that can speak like humans. There's none of those. It's rather starting with very structured data sets, so an Excel spreadsheet that has your zip code, your address, right? So just sort of boring structured data. But then the cool part is you can take quantitative relationships in data sets now, and these things will automatically write articles that represent those quantitative relationships in qualitative terms. So you might be most familiar with this in the Associated Press. All of their company earnings reports are written by these systems. A company called Automated Insights, also out of Raleigh. Cool company. We did a webinar with them if you want to learn more. They are the company with whom the Associated Press partnered to do this kind of work. So this works for weather reports, sports reports, right? It's not interpretive journalism. It's starting with structured reports. At my company, just to illustrate how this stuff works, we built a real estate ad generator. So if you see that top line, you can put in some structured data, how many bedrooms, how many bathrooms, where is it located. And then we trained this on I can't remember which listings it was, but it was like Street Easy or something like that. So we had a whole corpus of existing real estate ads, and we set up, this is actually not a super sophisticated use of AI. It looks neat, but on the back end, it's just a rules-based oriented scoring set where it goes through, it scrapes its corpus. So you can see in 20 seconds, it can write 1,300 real estate listings. So with respect to productivity and efficiency, it's much different than human levels and capacities. But it scrapes through, it picks out sentences, scores them according to our input, and then we'll just generate these ads. We learned some cool things about and I'll talk about bias and stereotypes within data sets, about correlations between the language that real estate agents tend to use and these structures. So anyone who does live in New York and is going to be looking for an apartment, if you see words like a spacious space or something cozy always means that it's a couple of standard deviations below what it should be with regards to square footage. If it mentions size at all, that means it's on par with the average, and if size is not mentioned, it might actually be spacious. So you pick up things like that. In companies and practice, Most companies are using this for business intelligence BI, so they, a lot of people aren't quants. They don't like data sets. They don't even really like visualizations. They love emails and words. Brian Cave is the only law firm I know of that's actually built one of these in-house. Brian Cave is super cool with regards to innovation. And they actually have done doing it for automated profit reports for partners at the end of the year. So the partners, they don't like data, but they love to see this stuff, makes it easier. I'm interested in as we talk about sort of how this stuff shifts the economics and thinking about how much legal services should cost. I think this would be a neat analytic tool where you could get a little bit of a sense of X matter costs Y type of matter in a transactional practice costs Z, and just make analytics more friendly as law firms start to think about matter-based pricing versus billed hours. More interestingly, so I assume everybody's familiar with Rocket Lawyer, LegalZoom, et cetera, the document automation tools. On the right-hand side, it's hard to see with the light, but have you guys heard about Joshua Browder's new robo-lawyer? Okay, so this kid, he's 18 years old at Stanford, just built this chatbot that is an advocate for parking tickets. So you go down the street and you have this little chatbot that comes up and you can say, all right, enter in some information about the conditions of where you've parked, and it'll basically decide whether, gives you some advice as to whether or not you can appeal that ticket. So I think that this template-based, you put in some information and you get out a created template, is very different from real-time reasoning-like information coming out of these new bots. So what's going to have to change in order for a bot-type legal advocate to get adopted? So the case, LegalZoom, Rocket Lawyer, et cetera, these guys are in business today because they've managed to overcome a bunch of potential class action lawsuits against their adoption where they've cut out these Scrivener exceptions. This comes from the case in 2014, LegalZoom versus North Carolina State Bar, where they basically say this isn't actually legal judgment. When we take a template that's generalized across multiple use cases and we don't actually tailor it to a particular set of circumstances, it can evade that which qualifies as the practice of law, and therefore LegalZoom and Rocket Lawyer, these aren't law firms, they're a different class of service. Back in 2015, the battle continued, and there was an antitrust case against LegalZoom, and they again managed to sort of get out of it with some smart lawyers on their team, where there was a set of conditions that were set. So in all of these template-generated services, first have to be reviewed for a lawyer, so they make sure that they're safe for the public. They have to communicate on their site that this does not constitute legal advice. They have these sort of upsell services where you get a couple of minutes with a lawyer if you need it. And there's some interesting stuff about dispute resolution that has to do less with AI and more with virtual advocacy from a distance, where if there's something that does go wrong, they have to make sure that the consumers have the ability to redress that in their state. The big question that I have with new generated text and where AI is going is the more particular it becomes and the more advocate-like it becomes, would it get hit by these clauses that have enabled LegalZoom and Rocket Lawyer to succeed as they have, or not? Shifting gears, so Larry mentioned deep learning and NLP in his presentation. So we just did a project on automated text summarization. So you have a very long article, you throw it through our system, and it spits out the 2 sentences that best represent the content of that article. Significantly, just with regards to where we stand with AI, when we did the research for this, we felt that the systems are at the point where they can extract out existing quotes, and that's how they summarize. They don't rewrite things, they don't understand it, right? They're not doing what we would consider to be a good human written abstract. They're able to extract. So, this true abstract of rewriting things in its own words is probably, at least 10 years out with regards to where the top deep learning systems stand. So just to illustrate that in practice, here's a New Yorker article about El Chapo. I really want to do the Sean Penn one because that's super long, but this is really long, relatively long too. It's 39 minutes of reading. If you put it through our prototype brief, there's the El Chapo article on the right. It's a little hard to see, but there's differences in the vibrancy of the yellow highlighting. So it stratifies the sentences. The dark red highlighted ones, yellow highlighted ones are the ones that are what the system considers to be the key sentences. Yellow ones are in second place, and the rest of it is sort of filler information. And then on the left-hand side, here's those key sentences. The 1%, 4% are where they stand within the document. So you can it changes the way you read, right, as a user to sort of enable you to focus on the core information first and then push through. We're doing a lot of work in applying this in financial services and hedge fund settings where research analysts are, they get oogles of information from Bloomberg and all of their internal reports, and they're trying to figure out how to manage that to place trades. That technique to use on this system uses a lot of fancy, cutting edge, really interesting new stuff in the deep learning space. I'm happy to talk, if you guys are interested, a little bit later on the architecture of what makes this work versus image recognition, so looking at a picture and knowing that something's a puppy or something's a cat. I think the main legal application for image recognition is in mixed media discovery. So if there's any litigation in medical malpractice, et cetera, it could probably parse through a set of x-rays and identify those which could be affiliated with a medical condition or not. So this second type of summarization algorithm that we've explored uses older technology, but the use case is different. So this is one where you've got 1 million documents, not one document, and you want to go through and say, what's this about? What are the topics that are in this corpus of 1 million documents? So this technology goes through, we put it on Amazon. We wanted to say, when you're going to go buy a book and there's 50,000 book reviews, how do you get the meta, like the OR book review, right? So we built an OR book review system. It clusters together different topics, and then it spits out sentences that are most representative of the topics, the topics at hand. So legal use cases, there's a lot of e-discovery players on the market. Larry mentioned relativity. None of them are using, from my knowledge, there's a couple of newer ones, but none of the key players are really using the newest language modeling techniques. So I think if you guys follow the literature here at all, Mara Grossman and the active learning discourse is sort of the state of the art with regards to getting actually high accuracy on document review sets. It doesn't happen automatically. A human is always going to be in the loop. So for the next 10 years or so, it's not like all paralegals are going to be automated. It's that what they do in doing document review is going to shift to help train systems to collaborate with them as opposed to just automating them away. Same thing for deposition digests, same thing for contract analysis and doing due diligence to try to find similar terms. What are the ethical issues? So the key thing with deep learning systems to know, and I think this would be a huge obstacle for adoption for any dispute resolution, is they're what the tech community calls uninterpretable. So what that means is they do amazing things, like say that there's a puppy in a picture or a cat in a picture, but not even the best technologists in the community know why, right? So there's a lot of complex emergent, they're emergent systems. There's a lot of complex math going on under the hood, and they can discern aspects and features in data sets and affiliate those with outputs and labels, but the math under the hood is it's completely uninterpretable. So in healthcare and financial services, this stuff is basically non-existent because they prefer to stick with less sexy, less accurate, but entirely transparent models so that if the SEC comes knocking at their door, they can explain exactly why they decided to provide a load into somebody and not somebody else. Other interesting ethical obstacles here. So the technique that we use to do summarization is something called a word embedding. Super cool stuff. It's very different from traditional NLP technology because what it does is it doesn't consider language as language. It first tries to map it to a number space. So it takes a word and it does a little projection of it into a vector, right, in a number space, and then it measures the distance between different vectors to try to find things that are similar. So there's this research that came out from a group of researchers at private sector academic research led by this guy Bulofsky. And they said, well, let's look at if there's existing biases in our data set that we use to train the systems to be smart, right? Because basically it's always, all these systems are monkey see, monkey do. They don't think, they imitate, right? So it depends on what they're given. And they said, they like to play these games where they do word analogies, right? So sort of word algebra. So man is to king as woman is to what? Queen, right? That's one really, we're comfortable with that use case. But if we bring it up to today, they put it in their data set and they said man is to computer programmer as woman is to home baker. And even better, the next one, black male is to assaulted as white male is to entitled to. So, these algorithms are not evil. Algorithms are neutral. Algorithms, but they tend to reveal the evil that exists in our own society. And technicians and practitioners that are building them often, I just read Andy Stern's book called Raising the Floor about universal basic income. And he starts off with the MIT Media Lab and sort of interviews a lot of people that are doing research there. And there's really amazing question going on right now, which is, do regulations hinder innovation in such a way that we wouldn't have the cool developments, right? Do we need to leave creativity unbridled in order to innovate as much as possible or not? So he sort of starts out and he said, these people are building these amazing things, but with no considerations whatsoever of the impact that they could have on people's livelihood and society. So similarly here, if people are building out neural networks to try to do amazing things like summarize text, right? This stuff will happen. Should they consider that at the beginning and restrict their systems, or should they allow for full development and then restrict afterwards? So I think this is a really, really big question right now. On the legal side, 2015, great case. I highly recommend it if you haven't read it yet, Lola versus Skadden. So David Lola is a California licensed lawyer who decided that life in corporate law sucked, and he just wanted to do document review and be able to spend time with his family at night. So he moved to North Carolina and became a reviewer for a case at Skadden. And he worked 55 hours on average per month, and he was not paid overtime. And he was not paid overtime because his work was considered something that was this is what associates do. You're a lawyer, you're in for the fight. And he said, well, I'm not a lawyer. I should be considered staff, and I deserve my overtime pay. And so it went to court, and they said, well, gosh, is document review the practice of law or not? And the North Carolina Supreme Court, again, said that they had this, in trying to figure out whether it was or not, they came up with this bright line standard, which was that if a machine can do it, it's not the practice of law. And those of us that are active, Noah Weisberg up at Kira Systems in Toronto, there's a faculty blog group that I'm active in. We're kind of like, this sucks, right? This is not going to cut it going forward. So the questions going forward are: is this a good bright line standard in the age in which we have Ross assisting with legal research, we have Kira assisting with due diligence, right? We need to reconsider the blur and the balance between man and machine as we consider what qualifies as law, and that's going to have a big impact on the economics of firms. If they need to reconsider how they're paying allocation of work between man and machine, and then the way in which they're considering staff versus lawyer. So what needs to happen? So I've done a lot of work in the rules and professional conduct because I used to sell to general counsels, and I needed to learn how they thought. And under the ABA 2020 Commission, there was these updates, and a lot of the updates regarding technology were designed to think about the core concern being privacy and security. So that's still important, but as mentioned, there's new benefits. There's, in order to do this in a cost-efficient manner for clients, there's all these new systems that lawyers need to know exist, but they also need to know the risks associated with them. So I think there should be sort of a ABA task force devoted to the use of AI in law. I think that in this community, right, so lawyers need to also educate technologists. There's very little dialogue between the policy side, the practitioner side, and the data scientist side regarding, so what are these ethical issues? And if I build this cool system that do things, why aren't you using it, right? So both to to further innovation as well as to guard against these risks, there needs to be that dialogue. I'm a big fan of alternative business structures, so I think that law firms need to be liberalized so that they can buy technology and have it not come out of their profit cut. And I also think that there should be some cool discussion around what qualifies as, the authorized and unauthorized practice of law going forward. Thank you.
I guess it's
But
Yeah.
from an innovator's point of view, that gives you the world to explore, right? Because anything that your machine is doing is not the practice of law and therefore is not going to be subject to unauthorized practice.
Fair. Yeah, that's a good idea. So like the legal Zoom caveats, right? So if it's not the practice of law, then you can actually use it. That's interesting. Yeah.
Why would Noah not like it?
I think for him it's more from the perspective of like, I didn't know, Noah's, if you read his blog, I can send you it. Like it didn't really go into, and here's the economic implications of this, the way that I teased out in the Lola case. It went through in conceptualizing, right? It's more about, in his view, I'd imagine, like why I'd put this up on the Kira blog. If he's trying to sell his product to law firms, and law firms are resistant to using technology because they're like, I don't know if systems can do what humans do. So you'll see a lot in the e-discovery world. Back to like the silver bullet, there's still a lot of resistance to adoptions of these systems for e-discovery because people feel more comfortable with manual review, even if they have million entity document sets where the possibility for mistakes from a human vis-a-vis a machine, and these are probabilistic systems. They're going to say, I think this is relevant, and I'm 75% confident, right? So they're not fully automated, and I think that the lack of comfort with sort of using probabilistic systems within workflows is still a big obstacle for resistance. So I think Noah's point there was we need to think about like the sophistication of these systems today. But I think you're right from an innovator's perspective. That's interesting. Yeah.
Following up on your last point about liberalization of business structures, do you think that that would include an equity position in a business for a non-lawyer who is a technologist in order to change the incentives inside the business structure? And I ask that from a North Carolina perspective. We're going to be the first state to advise that, I think, and I don't know what the rest of the world is talking about.
Happens in the UK.
Yeah, that's right. John knows that.
It doesn't matter. There's no problem with it whatsoever.
Did someone repeat the question?
On the mic.
Sure. How will liberalization of the business structures, including equity interests for non-lawyers, foster innovation? Was my question.
Yeah,
or will it?
You need it in the mic, though, so people that know.
So the question is, how will liberalization of the business structure, so allowing non-partners to have equity positions in law firms, encourage innovation?
But do note the point. Lawyers are the only ones who describe other people by saying they are non.
Yeah.
You don't get non-engineers, you don't get non-techs, you get non-lawyers.
Yeah, I would say being
that says something about the bias.
Yeah, the hero, like, if you work in a non... Yeah, but the truth is, though... No, but, like, the second-class citizen status that's like, awarded to, to non-lawyers and law firms. I think this, it goes to Susskind's book, I'm just reading right now the Professions book, and, yeah, this notion of, I think that in an age where, and it's interesting with the blockchain stuff too, in an age where there did need to be some sort of guild structure that was a guarantor of trust so as to, enable there to be an effective delivery of people who know stuff about something to people who don't know stuff about something, but are reliant upon the people who know stuff to get stuff done, right, then, lawyer versus non-lawyer is quite relevant and even important. And in particular at an age where, like, part of being a part of the profession is to also manifest civic goodness, and push society forward as opposed to make profit for your firm. And I don't know, I just feel like with the blockchain and with just the internet in general, the mechanism and gears of trust to disseminate information from the experts to the non-experts needs to be reconsidered as well. So.
Thank you, ma'am.
Hi, everybody. So my name is Amy Wan. I am one of the co-founders of the LA Legal Hackers Meetup, and my other co-founder is back there, Aria. I'm going to try and make my presentation pretty short today because I'm splitting my time with Ken because he's doing really amazing stuff. So let's get going. So basically, crowdfunding and alternative finance. I'm sure you guys have been hearing a lot about it lately. There's a number of new regulations, and since we have a lot of attorneys in the room, I'm not going to go too deeply into the regulations, just a quick intro of them. But really what I wanted to talk about today was why I'm doing it, why everyone else in the industry is doing it, and what potential it brings to the to entrepreneurship. So, following down here, I have X'd out my company name or my law firm name. But basically, I began my, if you had told me when I started law school, 9 or 10 years ago, that one day I would be practicing corporate securities and financial services law, I think I would have, said, Amy, at what point did you sell out and why? I actually went to law school to be a human rights attorney. And, I thought I wanted to fight the good fight and all that sort of stuff, but I promise all of this actually makes sense. Because at the end of the day, crowdfunding is all about democratizing access to capital, so entrepreneurship opportunity, and democratizing access to investment opportunities. So no longer do you have to know the stodgy guys at the country club for which you pay, $10,000 a year or whatever in fees to be able to network with these guys, or Equinox or whatever it may be. People like you and me can actually if we have the concept of a new company, we can raise money through the internet. It's not just this exclusive club anymore. I actually started my career in my 1L summer. I worked for the Fiji Human Rights Commission, and that was the summer that they turned from a democracy into a dictatorship. And I quickly learned that human rights law does not necessarily cross borders, or at least dictators don't really care about it. So I wanted to try and find something that people or leaders really did care about, and that, at the end of the day, I thought was economic power. And so I spent a couple of years in federal government. We did crazy stuff at the WTO, doing international trade policy, international regulatory coherence. And at the end of the day, the government is great. It's got a lot of great people, and our job was always to make America number one. And we did that by trying to make sure that American companies could do American exports, could hire American people for American jobs. And I think really that's what crowdfunding does. So I left a couple years ago, joined this tiny startup called Patch of Land. At the time, it was 3 founders. They specifically did real estate crowdfunding. So basically, during the recession, Chicago was having a lot of dilapidated neighborhoods. They were having problems with squatters, and neighborhoods were falling in value. They were seeing a lot of increase in crime, and Chicago actually has a policy where if a residential home is not occupied, they would rather tear it down, which is a huge waste of money and resources. And so that startup, we grew to 45 people over 2 years, went through multiple funding rounds, and at the beginning of this year, Title III became effective and presents a lot of very interesting opportunities for a lot of very creative people, and so that's what we're here to talk about today. So crowdfunding, I think there was a statistic that came out in the middle of 2015. And that statistic said that internationally, crowdfunding raised $35 billion in 2015. I don't know what the 2016 statistics are, but it's astronomical. How many of you here know about Kickstarter, Indiegogo, GoFundMe? Great. That's not what we're here to talk about today. So there's 4 different types of crowdfunding. GoFundMe is really donation-based crowdfunding. So I give you $5, and in return, I get good, happy feelings, right? Kickstarter, Indiegogo, that's rewards-based crowdfunding. I give you $5, and in return, I get maybe my name, in a thank you card, or maybe if I give you $1,000, I get to have dinner with you, or whatever widget you're building. But it's not a monetary return on investment. Today, the type of crowdfunding that we're talking about is the type of investment in which you will get a monetary return, and that really is equity and debt crowdfunding. Now, debt crowdfunding is more popularly called marketplace lending, and it's been popularized in the past 7 to 8 years by platforms such as Prosper, Lending Club, SoFi. A lot of you guys might be using that to refi your student loans. They don't have as much of a marketplace lending model, but it goes a little bit that way. And people have also been applying it to the real estate sector, so real estate lending, right? Equity crowdfunding is the one that a lot of people are really excited about, and that's where regular investors like you and me, non-accredited investors, might have the opportunity to invest in everything from the next Uber or Facebook, all the way to owning a little tiny piece of your own microbrewery, which, just so you know, of the campaigns that have gone on in the last, 50 days under Title III, a lot of, the alcohol-related ones are doing particularly well. So at least in the US, crowdfunding regulations came out of the Jobs Act. There's 3 different regulations, and it's taken the SEC a couple of years to get it right, but this is the old capital raising timeline, right? So accredited investors are basically high net worth or high income individuals, and then there's the rest of us, right? The retail or the crowd investors. Traditionally, this might be your seed round, your Series A, B, C, how many you want to do. Maybe your exit is a merger, maybe it's an acquisition, or maybe you get really lucky and you go IPO and go through that whole process. Retail investors traditionally, for the most part, generally, have not really been able to invest in these very interesting companies until this stage. What crowdfunding does is it lets us invest at an earlier point in time. So early on, you might consider a Reg CF, a Title III offering. The Reg A Plus is considered a mini IPO, and you can get into these companies earlier before the valuations are so high that you don't own a lot of the company anymore. So I'm just going to go through some of the regulations very quickly, and the most important thing to remember is what the SEC giveth, the SEC will probably taketh something away. So what that means in practical terms is the more freedom they give you in terms of allowing you to take money from either non-accredited investors or allowing you to go and broadly advertise through Twitter ads or Facebook ads or whatever it might be, the cost of that is that they're going to ask certain things of you. It might be legal reporting, it might be audited financials, and it really depends on what regulation you're doing your offering under. Now, the old private placement exemption, it used to just be Rule 506. Now they've given it a letter. It's 506B as in boy. That's what the tech community, venture capital, and all of those have been raising money under for a long, long time, right? What that says is you can accept money from accredited investors only, plus 35 sophisticated but non-accredited investors, and there's no cap. You can raise as much as you want. But this old regulation said you cannot do any sort of general solicitation, general advertising. It has to be closed doors, pre-existing networks only. The legal term is a substantial pre-existing relationship, right? Now, the first of the Jobs Act crowdfunding regulations that came out is 506C. Now, it's still accredited investors only, and this time you can't take any non-accredited investors. But you can advertise as much as you want, as long as you're not saying crazy, fraudulent, misleading statements, right? The cost of that is, whereas under 506B, we had this substantial relationship. I know that you are a very wealthy individual, that you're pretty financially savvy, and I'm not actually going to ask you for your tax returns or pay stubs or anything like that to make sure you're accredited. Under 506B, you do have to take reasonable steps to verify an investor's accredited status. Because what they don't want to see is, hey, we've solicited all, and caused a lot of hype from all these people, and it's so easy to go on the internet, click, a terms and conditions, click, oh, I want to invest $5,000, but do I really have $5,000 to lose? So that came out in fall of 2014, and it's actually been pretty widely adopted, I would say, especially in the real estate industry. Now, Reg A Plus has been effective for about a year now. It came out, I want to say, June 19th of 2015, and that's what everyone's calling the mini IPO. So Reg A Plus basically allows you to raise up to $50 million from non-accredited investors. Now remember, whatever the SEC giveth, the SEC will take something away, right? So the cost of that is that you do have to go through I call it like a pseudo qualification process. It's not like the full-on IPO, but you do need to be able to produce financials. You really should have an attorney draft your offering document, right? And then every year after that, you will have to submit and go under some sort of reporting requirement. Not as crazy as if you were a public company, but people are calling this, IPO light. It allows you to really raise capital from non-accredited investors. And the beauty of that is really you can turn your consumers, your loyal customers, into your evangelists because they have some sort of equity stake now in your company. The last one is Reg CF. It's also called Title III, and that's actually only been effective for about, I don't want to say 6 weeks now. It's the newest one. It's the most interesting one. It allows you to take money from non-accredited investors, but you can only raise up to $1 million every 12 months. Also, you do have to fill out a small form, not a full-on registration, qualification, whatever process. It's much simpler, but you do need to have your financial statements in order. And then there are very, very light reporting requirements, but they're still kind of there. I wanted to keep my presentation pretty short because we have a special guest today, but I did want to quickly show you some of the interesting statistics we're seeing out of the first, the industry so far. So, sorry, you don't need to see my calendar. So basically, this is the first month of Title III equity crowdfunding. So, it's interesting because if you look at the statistics, not everyone is necessarily trying to do an equity raise, right? You're seeing a lot of debt things, right? It might be in the form of a convertible note or a SAFE, which Ken might be talking about. Traditionally, venture capital has been very much concentrated in San Francisco, New York. You're slowly starting to see it spread a little bit more across the country. In the, I think, the first month of Title III, we saw 44 issuers, and there's different models of funding platforms. Some of them highly curate, and some of them are more listing portals like a Kickstarter, Indiegogo. So it's going to be very interesting to see what type of portal model succeeds. I think the average offering amount right now has been for about $130,000, and you're actually seeing this not as popular for tech or VC type companies, but really brick and mortars. So, like I was saying, a lot of breweries, distilleries, anything in what I would call the Vice Index, right? There's been a lot of calls from cannabis clients. Because they need access to alternative finance. For Reg A Plus, the mini IPO, it's very interesting. The average legal cost over the past year for offerings has been slightly over $100,000. But that's highly, highly inflated, I think, because if you actually look at the distributions, there are some firms, there's actually a good number of firms that are around $50,000 or less. There's obviously the big law firms who charge a lot more. And then, of course, there are two particular law firms who have done interesting things because, you know, this square right here, the most an issuer has spent in doing a Reg A Plus has been about $500,000, but to date, those two issuers who have spent about $500,000 have only raised $500,000. So you have to be very, very careful about making your security marketable and feasible. Like I said, Reg A Plus does take a little bit more time to actually go through the whole qualification process. So we're seeing an average of 109 days, but that's from the date you file. You have to give your attorney basically time to actually draft the document as well. So a lot of very interesting statistics on what we're seeing from the industry so far, but I really want to bring up Ken to give us the ground level report. And Ken is very humble, but he's the former GC of AngelList, so we're very lucky to have him.
Hi, everyone. I'm Ken, and I'm a legal hacker. It's not a name that I gave, to myself. I actually was hired at AngelList as a legal hacker in 2012. To the outside world, I was the company's general counsel. Internally, I was a legal hacker. And what that meant is that you know what the problems are, and you understand what the laws say, and understand the gray areas so that I find ways to navigate it. And if the laws do not allow you to do it, then change the law. And that's exactly what AngelList did in lobbying for the Jobs Act. So now that I'm a COO and founder of Republic, and I'm gonna explain it a little bit more, I still consider myself to be a legal hacker in many ways because what we do is highly complex on the legal end, and so navigating it and finding new solutions is absolutely crucial. So the story of crowdfunding and the evolution of crowdfunding is basically a story of legal hacking. How many people here know what AngelList is or has been to the site? So many, but not all. Let me very quickly hone in on why AngelList had been described by Harvard Business Review as one of the most impactful disruption to venture capital in the past 50 or 80 years. So prior to AngelList, as Amy said, you gotta know one of 3 dozen guys, mainly guys, in Silicon Valley to get funding. And it doesn't matter how wealthy you are as a surgeon, as a lawyer, there was no way for you to get in on an early deal like Uber. So AngelList is known for connecting investors and entrepreneurs online. Uber raised its very first $1 million on AngelList. Had you invested $1,000 in Uber on AngelList, now that would be about $14 million in fair market value. So that's the reason why that notion of diversifying venture capital is so powerful. So to date, in the past 3 years, AngelList has funneled more than $350 million into over 1,000 companies, including Thumbtack, TalkDesk, and so on and so forth. So, that all sounds amazing. What is there to change, right? Well, first, let's look at the demand from non-wealthy individuals. And this picture kind of says it all. Every single week, 5 million plus individuals, Americans, log in to see and follow the story of entrepreneurship. Now, taking that to a different angle, every single year, Americans spend $60 billion on lotteries, and we lose $120 billion at the casinos. If you manage to put 10% of that into entrepreneurship, imagine the kind of change and the impact that you would have. So that's on the demand end. I want to show another chart here. At the top, it looks like this is the demographics of Donald Trump's supporters, but they aren't. This is where the flow of venture capital, about $40 billion per year, where does this money go? They go into companies that are primarily male, 97% with a male CEO, and predominantly Caucasian. 45%, 43, goes into apps, like Snapchat, and 57 are in California. So obviously, innovations and good ideas exist everywhere. Where money goes is in pocket. And that's where I believe that by tapping into the general public, by democratizing investing, we're gonna match the distribution of financing more with the distribution of ideas and innovations. So I left Republic about 3 months ago, leaving in the sense of AngelList is investing in our company, and so it's basically a partner. Basically on that notion of investing meets, democracy. Due to the fact that there was that recent change in the law, not that recent, but it started in 2012 and finally became legal about a month ago, or 2 months ago now. Now, moving back to legal hacking, now that we have a policy shift, and there was a lot of work by a lot of people, AngelList included, the law is not perfect, as Amy said, and how to understand what the limitations are and how to navigate it. So one major limitation is that companies that do Title III gotta disclose their financials to the public. That's not palatable for most companies. The unicorns in Silicon Valley, I know at least 3, that are value above $1 billion, but their annual revenue is below $50 million per year. So they're not gonna be in a rush to adopt Title III because, it's bad PR. For everyone else though, if you run a business that you don't mind financial disclosure, I think that's pretty much like the only unsolvable hurdle for now. Now, Amy touched on something called a CrowdSave, and as our proprietary legal product that we push out, that solves something in venture that's known as a messy cap table. No one wants 8,000 teachers and house cleaners and lawyers as your shareholders. That's a lot of work. So we push out a product, in short, that would allow founders to have these people on as investor, but never as shareholders. So they don't have information right and they don't have voting right. If you want more information at the link below, you can find out a whole lot about it. This is brand new. I'm sure there are a lot of hesitance and resistance about the legality of it. My background is, somewhat complex. I started out with Proctor, became a general counsel for a hedge fund in New York, moved back to Stanford to teach law for 2 years, went to private equity, and then went to AngelList. So I met with the SEC on a quarterly basis. I probably have how about this? I have confidence and conviction that this product actually will meet regulatory scrutiny. But like everything with hacking, you gotta know how far to go. If you go too far, you become a criminal. And if you don't go far enough, nothing is gonna get done. You're just gonna follow the trend. So we have the CrowdSave, right? I'm sorry? No, a CrowdSave is, are you familiar with Y Combinator's, a convertible note? So Y Combinator has a document and this is a derivative of it. Yep. So what do all of this actually mean to legal entrepreneurs? It means one thing. If you're so well connected, you can get Sequoia or heck, even go in AngelList and get money. They may, please do that. But I think legal as an industry is so big and there's so many good ideas out there. If you don't know people in venture, but if your idea somehow can strike a chord with the legal community, if you can get 1,000 lawyers, each putting $500 in you because they believe they want to see a change, you get $500,000 to kickstart your business, or on Republic hopefully, and not on Kickstarter. So Title III is about fundraising and branding and marketing at the same time. So investor on Title III invest with their head, but also with their heart. I really think that, and that's where our focus is gonna be, on mission-driven entrepreneurs, and hopefully a community that wanna see a different future and support without counting dollar and cent on when I'm gonna get my money back. Republic, at the end of the day, we're building a community, and I'm lucky enough to, having been in the venture ecosystem, to really corral some, experts to really build and help and nurture the entrepreneurs. So Naval Ravikant is the CEO of AngelList. He's our advisor on the board. He understands venture very well. So with him on the platform, providing guidance, hopefully entrepreneurs later on would be able to get venture financing as well. Shiza was the CEO and founder of the Malala Fund. Malala is the girl who got shot in the face by the Taliban. Shiza left McKinsey, went, found her, built a fund, and she got the Nobel Peace Prize as the youngest woman or person at the age of 16. She since left that platform and now focused on entrepreneurship, and we're really lucky to have her, as an advisor. Similarly, we land on design expertise, campaign expertise, legal expertise. Hopefully, Amy one day will be an advisor for Republic as well. That would be awesome. So let me stop here, and so that Amy and I can take some questions. But I'm doing a product hunt live chat with Naval next Friday. So if you guys want to learn more and want to talk to Naval directly, go to product hunt and just log on at that time.
Thank you very much. So I want to do two things with the talk briefly. But first, I want to point out that my remarks are not representing the federal government or my agency or anyone in Japan. If you have questions about that, I can talk about why that's on there. Normally there'd be a longer joke with that. But you could probably do about an hour of billables looking at what innovation policy is. I've got probably 3 or 4 slides. We're going to run through that. Now, what I really want to talk about, though, is there's 2 tracks of people I think we encounter in sort of the legal hackerspace. There are predominantly attorneys who have some law and technology nexus. I'm very excited to see a lot of FCC colleagues here, people who have sort of a nexus in technology affairs, and they're practicing attorneys. I think that's a big contingent. Another group tends to be technologists who are sort of entering roles that are very traditional in a sense. If those of us who've worked in startups knew the engineering guy that was the sales or pre-sales or other guy. People transition from technical roles into law and policy roles, especially in Washington, pretty easily. You'll often find in APA rulemakings an attorney paired with an econometrician or an engineer or someone like that. So what I want to do today is talk through, first of all, what I think are really exciting things going on in federal innovation policy. I think that's a good sort of name. It definitely has got legs right now. And explain why I think it's a very rich area for people, especially lawyers, who see that we're probably exploring something very exciting right now, the development of an area of practice that merges necessity of technical skills with necessity of legal skills, much in the same way that law and economics evolved out of Posner and a lot of other environmental sort of effects maybe 15 or 20 years earlier. So that's really, I think, what we want to come away from the talk today about. So to dig in, I think I had done a congressional fellowship around 2008. My obligation to the government was expiring. I was thinking about leaving government, and then a really magical thing happened. We had an election, and I was like, well, that actually doesn't make me want to quit my job. Now, we'll see what happens in the fall. But the administration came in and embraced technology in a new way. And I think one thing that was interesting today is we haven't heard the word disruptive, but one time, and I think it's really interesting. This has been a very disruptive administration in a lot of ways, from a legal and sort of a law and policy perspective. And what they did was they came in and said,
government needs to be transparent. And the president spoke in that voice and said, we will make this government transparent. We will make it participatory, and we will make it collaborative. These are really important things because at that setting level, if you're head of your agency or the head of the federal government says, these are priorities, all the folks that have been in the background trying to do exciting and new things have legs to stand on. And I think what we'll talk through also are how that description sort of set the stage for a lot of other things. In 2009 in particular, we talked about innovation as a strategy. And we talked about how it was going to be focused on different sort of areas. But one in particular was innovating the function of government. So if we have a legal hacker, I think there's also government hacking. And sometimes that name sort of comes up. But I think that's more or less what the theme is from a legal sort of law and policy perspective. And that theme has been developed and expanded through the administration. I'll spare you the citations, but again, our billables, there's several of these things. There's a lot of OMB guidance, a lot of things at the agency level that have been going on. But generally, I think one of the things we want to emphasize is that it defined an open federal data as an asset, as a national asset that was going to be publicly available. We've seen how that sort of has already taken on sort of tangible benefits. But some of the things we talked about is increasing the efficiency of government. I'll talk a little bit about crowdsourcing, which is really what I've focused on predominantly. Improving accountability, this is an obvious point. Anyone that knows folks from Sunshine or other areas, clearly that's got a very long history in the law, and certainly there's a lot of innovation, but these are all drawing on, essentially sort of common sense ideas that you can take advantage of things that are working in one context and apply them in another. So I think the other thing that we want to take away from this is as people started to engage on the topic, a lot of really cool ideas started to emerge. Things like, well, you could harness, the idea of prizes and challenges and do new and creative things with procurement and funding. For those of us that work in agencies that are regulatory, it's not such an interest, but for areas that do grants, it was a hugely powerful effect. Things like crowdsourcing and citizen science, I'll talk a little bit more in detail, but a lot of agencies, their bread and butter is collecting information. Where does it go? How do you do that? What are efficient ways to do that? How do you do it within the context of different sort of legal requirements? I'll talk about that in detail. We talked about an innovation toolkit. If you are a staff attorney sitting at your desk trying to get something done, is there someone that has gone through the 6 months or 1 year of legal research, so I don't have to spend my off hours doing that when I'm still going to be at my desk doing all my other boring work that will take twice as long as it would if I had the toolkit already. So we talked about this and how we build sort of on this idea of making government more responsive, more sort of evidence-driven. These things are all really important topics. How I got involved with this is sort of on two fronts. I had some computer science background, sort of worked in sort of that space between actually developing software and sort of liaison roles, worked in the Bay Area at the end of the 90s, came to DC for law school. So when I was at the FCC, I'd already sort of been one of the guys that had been inside of data centers, knew sort of what internet technology was, and started to engage on technical topics very early. One thing that is interesting, and as a short stint as our associate CIO for data and mobile strategy, the FCC is not thought of as a big data agency. But if you look at the legal permissions that are required to do collections, the PRA process, we were like the 13th most collecting agency in the federal government. In terms of the volume of data that the FCC collected, the variety, there's usually different sort of ways people describe big data. We were pretty big data, it turned out. And historically, the FCC has done it on a lot of fronts with a lot of different industry sectors, with a lot of substantive differences, and a lot of engagement also with consumers. So there was a broad sort of history of data collection in the FCC to build on. Around about the time that we started to think about broadband as a new policy platform. Everyone's probably familiar with the National Broadband Plan. People were looking at, well, how do you evaluate all these different sort of criteria? In the olden days, you had a voice circuit. You knew exactly how many minutes you could support on a given engineering sort of cycle. There were statistical models that described how likely a person was going to be using a call at a certain time of day, a certain time of a month in an area. These were all well-engineered statistical models that had 100 years of history. When we enter the internet market, we don't have those anymore. And so constructing what it means to have service or good quality of service or availability or what is actual performance realized by a consultant, we found that we didn't really have a lot of good data in this area. And so the broadband plan said, look, we need to go and create a platform that collects that data, releases it as open data, has a platform that's open and transparent and collaborative. And that's what we started to do with this Measuring Broadband America program, starting with fixed, and then later in the mobile context, we said, well, we can't do a statistical sample and meet the number of locations that we might want to survey, so let's try this smartphone thing, let's do the crowdsourcing idea. We had the benefit of our contractor that we work with already having deployed it overseas. And so we started doing a collection of mobile broadband data. That sort of got me involved with thinking through mobile privacy and how you realize sort of large-scale collections. How do you deal with issues around engaging with the public in different ways or have contributions from third parties that could, under procurement law or ethics or other sorts of things, raise at least legal questions. And so the other thing that was going on at this time were people like me in agencies all over the federal government coming together and saying, do you have any thoughts on this? What's your experience? Are you working on something? And there were a lot of these sort of groups that were starting to pool and cluster. One particular group that I became involved with was the Federal Community of Practice on Crowdsourcing and Citizen Science. And I have to give a shout out to my good friend, Dr. Leah Shanley, who sort of pulled me into this group. It had been going on for a while, but started from around 30 people and now is hundreds. And we have regular meetings, a lot of contact with the White House OSTP folks. So we developed sort of this interesting sort of almost staff-driven exchange that started to have very, very interesting and tangible sort of work products associated with it. So in particular, around crowdsourcing, we developed a toolkit. The first one that was sort of called out in that sort of innovation strategy was implemented looking at crowdsourcing. We looked at a lot of different things, but one of the things that I helped to lead up was looking at sorts of scenarios that a lot of us had experienced in developing and managing these programs. And they're fairly common sense. You've got PRA obligations. How do you sort of think about those in the context of web and sort of social media? How do you do procurement law when you're dealing with, models that don't always match the RFP sort of traditional contracting approach? How do you deal with open sourcing? How does that balance against confidence levels for consumers around privacy and how the government's engaging with their data? So there were a lot of scenarios we looked at and had been working through and generally different topics. These are just sort of a description of some of the things that immediately came to mind as I was putting the slides together, but around privacy and how academics deal with IRBs, whether that works real well in government, how you basically deal with a consent jurisdiction in the United States, even for federal users, and how that looks like, a terms and conditions for a smart app in some cases, admin law related stuff, ex partes, notice and comment issues, PRA, FOIA, Data Quality Act stuff. All of these are sort of different layers of that analysis. And of course, procurement law, just as an aside, we were working with our contractor, as is the case in a lot of agencies. Procurement is not always well staffed. We had some problems getting their invoices paid. I'm like, well, what do you have to do to get the invoices paid? Well, we need a contract officer's representative. And they're like, well, what does that involve? 40 hours of training on the internet. Okay, so you sort of developing experience in these areas as you eke around. So I want to segue back to the initial topic about how we take these topics and understand the evolution of this legal space that we might be talking about it. I like my slide. What does any of this have to do with Japanese law? I teach Japanese law. I'm a comparative theorist. I love Japan. And an interesting thing that sort of came to mind when I started working in this is comparative law usually looks at the different jurisdictions and isn't so much focused about, like in Japan, trilateral mergers. Does the stock given to a subsidiary that's used as the collateral for acquiring a firm and then merge back in to avoid shareholder votes, is that treated under the tax law this way or that way? Very narrow sort of implementation sorts of questions. There's substantive areas that you can look at which are typically described as foreign law. And the comparative legal theorist generally looks at the system and really is understanding, how does law function? Do we through this endeavor sort of understand something deeper about law itself? And so I think when we look at legal hackers, I think this space is a very comparative sort of perspective. We're looking at technology tools, which maybe those are substantive areas you might see as a foreign law sort of analogy. I mean, we're looking at how different sorts of processes could apply in different sort of contexts, looking at the systems and understanding comparatively how we can reach useful goals using different technologies, and understanding how that state is evolving. So again, back to that idea that in that space, there are two people who are starting to converge. People who come to the inquiry with a lot of technical background, and some folks that have a lot more focus on process and sort of policy and sort of structure around how you put problems together or categorize things. And I think actually what we can see is in things like data, there are a lot of places where these are really, really rich environments for attorneys also to work. I love this slide. Greg Ellen was at the FCC. I was happy to work with him on different projects. He was our first chief data officer, and he likes to describe open data as sort of a buffet. You don't serve guests at a dinner party a different meal. You don't serve them leftovers. You don't serve them food that's been sitting out and isn't fresh. And the idea that coming together and sort of eating together is this collaborative activity really carries a lot of, I think, really, really good storytelling around how open data and the storyline is so compelling for a lot of us. And so you've probably seen the open government data principles. These are really part of that dialogue and really come to the substance of why innovation policy, I think, and especially for us legal hackers, data is a good place to start because it is the food that we're consuming. It is the product. It is what we're preparing, is what we serve. It's really a buffet. And so whether or not you're prepping food or serving it or sharing it or choosing a menu, that analogy really carries true. And so if you're an attorney and you're looking at all the sorts of things that you could focus on, am I going to be an excellent sous chef or I'm going to do something else? There are too many legal sorts of topics to sit down as an attorney and say, I can manage this sort of an inquiry and then I'll be a data scientist or something like that. Data science and computer science are dense disciplines just like anything else. However, I think there are at least 3 layers of processing or sort of thinking about data, if we use that food analogy, that you can do some very focused research and learn a lot. And I think generally this is sort of modeling how people divide up sort of data science problems. But at some layer, you're going to be working with a lot of text. And so anyone that you'll talk to, if you go to a hackathon or a legal sort of legal hackers meetup, they'll talk about Perl scripts and regular expressions and how you take a data source that might be PDF and put it into a database format of some kind, a CVS format. Those sorts of problems are learnable, and they usually take a little bit of effort, but they are sort of problems you can scope and spend a fair amount of time on and master a set of regular expressions that match text and prepare it into a form you can start to do data with. Other skills relate to how you take that data and manage it and put it in a form where you can start to analyze and explore it. That typically is, maybe you want to start playing with Postgres. You definitely probably should invest some time in SQL. As a personal aside, I was pretty competent Perl and Java developer back even when I was in law school and never was a SQL guy at all. I got to the FCC, we had all this data. There wasn't really a mechanism for exploring it. I spent probably a good 6 months probably getting very competent with cross-table queries and things like that, basics of sort of SQL development. Again, something, if you invest the time, I think there'll be huge value to it. In that space also, you're going to be looking at statistics. As an aside, I got a little bubble. I think another thing to focus on is AI. Great textbooks out there, lots of things to learn from. Russell and Norg is the sort of textbook that I had looked at when I was an undergraduate. I think that text is amazing, but it gives you enough background at least to understand what sorts of problem sets are out there and how to attack them. At the end of the day, though, we're talking about storytelling in some sense. How do you take the data or the information that you've collected and explored and have some idea, how do you present that now? And another area that is, again, sort of a technical area is how you present that information in charts and maps and different sorts of visualizations. And usually you're going to have an emphasis on one of those 3. Unfortunately, I often have to sort of jump between stacks. It gets to be very confusing. But here's an area where collaboration and things of that nature are really, really important and valuable. If you can scale for things that you can't focus on, if you can bring a project to a level where it's sort of a minimum viable product that someone else can pick up, it's a huge value. So with that, I sort of want to leave you with the idea that if you didn't do computer science, if you've never had really experience with computers, it's no different than learning securities law. So with that, thank you very much.
The guy who, what's his name, Manashiki or something, Manashiki's the New York City data guy. He talks about data deserts. So when you have this, you're crowdsourcing your broadband data, the people who most probably need the underserved, the people who are not, putting up their data. How do you deal with getting data?
So, and again, with the limited time, there's a lot to learn. I would encourage people to reach out to the communities that work. Briefly, though, crowdsourcing in particular has a lot of really interesting elements, but outreach becomes very important. And so, for example, if you've got a skewing issue, you don't have people with the kind of resources to do a collection in the area because they're the underserved, does that present a collection problem? Is that sort of from a survey design problem, something people would look at? Sure. How do you deal with that? I think there's a lot of ways to think about it, and mostly it tends towards partnerships, how you have focused sort of work with other parties. But what's exciting about the crowdsourcing is that it sort of melds really well with those goals of being participatory and collaborative and open, and gives a person a chance to jump in and with their good ideas. So I think a lot of these things are like we all agree. More eyes on it tends to bring a better solution. Great, thanks again. Cheers.
Hi everybody, my name is Kanan, Dhru. I'm from India and I work on making law simple through comics. I'll explain where this came from. But before that, I just wanted to acknowledge how amazing and inspiring I'm feeling right now after being with all of you, especially after the presentation on AI and the blockchain. So I'm really excited about the diversity that exists in the legal profession. On one hand, there is cutting-edge technology being developed and phenomenal innovations are taking place, but at the same time, access to justice and access to legal information still remains an issue for millions of people out there. This is a true representation, I thought, of the legal profession, where you see so many black and white. And I think what we need right now is a fundamental innovation in way in which we interact with law, the way in which we understand law, and the way in which we disseminate legal information. Now, how can that be made interesting, fun, and cool for people across the world? What language can we use? What tools would be there to help us? Ignorance of law is not an excuse, we all know that. But how do we bridge the legal knowledge gap in the society? Especially when the legal information exists in books like this. Isn't it intimidating? Most people that we interact with, the non-lawyers, as somebody mentioned, would be so hesitant to look for their basic rights or the everyday laws that they need to know if it is presented in forms like this. So there's a very good saying which says, laws and institutions like clocks must occasionally be cleaned up, wound up, and set to true time. I heard a very interesting anecdote some time back that, especially in the context of the AI and the blockchain and all the interesting innovations that we hear about. So there was this person in 1860 who descended on Earth in 2016. And that person felt that the world has changed so much. That person really couldn't recognize that the face of the way human civilization was had changed so much and didn't know what to do and totally overwhelmed by what that person saw around. And then that person went to a court of law and felt at home. That person felt that he was or she was in 1860. And I think that has to change faster than we want it to be. So this is where legal design, law and design come into picture. What is interesting is that law and design are not brought into conversation often with each other, and this is a loss to both the fields. If we think about it, design and law share a fundamental purpose. This is to shape the way humans interact with each other. And if design thinking, processes, and practices are woven into the field of law, phenomenal things can happen and people will benefit tremendously. Design law promises, on the other side, it promises more efficiency, better relationships, and at the same time, the ways in which we can resolve disputes faster and more efficiently and more human-centered way. And there are projects which are taking place in different parts of the world, but I think this is where we need to come together and collaborate and create something very interesting and unique. So the idea is to make law simple, fundamentally changing the way we look at law, we disseminate law, and we understand law. I'm sure many of us out here love comics. I found a very interesting quote which says, I don't remember when exactly I read my first comic book, but I remember exactly how liberated and subversive I felt as a result. I'm sure there are comics in all our lives which have impacted so much and we still think about. It has shaped the way we think and interact with people. So why not law in the forms in which we can interact the way we interact with comics? But then there are mind blocks, and we think if laws can ever be made simple, especially in ways like this. But then that's exactly where we come in, and we are going to get our hands dirty by creating a comic ourselves. I'm going to help you with some tools. And then I think, as I said, we're working in groups here. And yes, I would like you all to dig in and take the theme of equality. I think equality could be of any nature, any specific instance that comes to your mind when you hear the word equality. It could be gender equality or racial or any other discrimination that you faced or you've heard or any story that you want to communicate. So we are going to be passing around papers and sketch pens. If you could just grab and start creating. I'll tell you what tools we can use before you start.
What are we going to do?
No, you can try. Yeah, whichever color they want. Yeah, okay. So I'll leave it to you to decide how many papers per group. Okay, awesome. Okay, before you start, there are some rules. There are some ground rules you need to understand that's going to help you make these comics. So these things are pretty technical, okay? So if you ask a comic designer or any artist, they spend their lives in things like this and still they don't think that they know enough. We just have a few minutes to create this, but this is just to get you started, and hopefully many lawyers out here can use these simple visualization tools to represent the information that can easily be represented through design. So first of all, start with an idea that you really believe in and want to share with others. It has to be simple. It has to be a personal story. It could be a story that is very powerful for you, an idea that you think is very profound. So take that, think about it, discuss in your groups. Second is storytelling. I think the previous speaker also mentioned it's all about storytelling. So how are you going to tell the story? Would you tell it from your perspective? Would you tell it from the perspective of as a third person? Would you just narrate it as somebody else is narrating it? So think about all of this. We don't have, unfortunately, much time, but think about it. There has to be a conflict in a story. It can't be simple. Even if it's just one frame comic, it has to present something which just straight goes to the audience's head as either it is hilarious or it just sparkles a thought. So think about what conflict that you are going to present, especially because we are going to be dealing with something like equality. Characters, that is very important. Who are your characters going to be? Is it going to be you? I mean, the discretion of how creative you want to be right now is totally up to you. You can create like a Calvin and Hobbes 3-panel, or you can create a 6-panel. You can just create 2 characters in the paper. That's totally fine. But please define who these characters are going to be. What are their qualities? What are their thought process? Where do they come from? Think about everything. So when we were creating Lawtoons, we had to go through the mind of the characters. What do they like? What they don't like? Which color the character is closer to, mother or father? What education they've had? What clothes they like to wear? Where do they go to shop? So please understand that characters are most important. If you see any interesting sitcoms, for example, let's just take Friends. There is no great storyline out there, right? I mean, there are 6 powerful characters who come together and create magic. So in comics or in any visualization tool that you're going to use, now or ever after that, make sure that the characters are powerful and interesting. The theme, I think that pretty much coincides with the idea. And the tone, are you going to be funny? Are you going to be provoking a thought? Are you going to be serious? Are you going to be sad? So think about that. The story is the most important factor that's going to be. So it looks like a design thing, but it's ultimately the story. So that has to be powerful. And then, most importantly, who's your audience? Is the audience you? That is also totally fine. You can create something for yourself. Is the audience going to be children? Is the audience going to be grown-up people who need to be provoked a thought into? So think about them. What are they thinking? Again, in design-centered thinking, most of you must have come across this idea that think as the user. So think about the kind of things that they like, the sitcoms that they watch, what makes them laugh, what makes them cry. So yes, keep them interested and make it funny. It has to be, don't explain too much. Your visuals should speak for themselves. So not too many words. Create visuals which are interesting. I think I'm talking too much. Please go now onto your papers and start creating something on equality. Think about it. It's possible. I think, yeah, I'll keep this. Okay, guys, I think there's too much. Okay, excuse me everybody, just a quick announcement. I think everybody's having too much fun, which is great. But yes, you all have just 2 minutes to wrap up, and then everybody has 30 seconds to come and present their comic to everybody else. Okay, so 2 minutes, 2 minutes. Okay, come back. Okay, so how was the experience? Woohoo! Good fun? Okay, so see, this is exactly what I wanted to communicate, that creating a law can be so much fun. I mean, doesn't have to be boring, doesn't have to be irritating. This is fun. I think the tool that we are using, visualization, comics, they are so interesting, and I really hope that you guys can take this back and use it in whatever ways you can. So now what we are going to do is that the groups, one person or all of them, you choose, should come here and explain your comic in 30 seconds to the rest of the group, okay? Good stuff. So who's going to come here first and explain their comic? Choose, no, you self-nominate yourself. Come.
Okay, the mic. I was saying we had a distinct lack of creativity and we had a distinct lack of artistic ability, but we were thinking about the lawyer versus non-lawyer thing, so we got real simple. So we have Atticus Finch, the lawyer, and all the little non-lawyers. And we thought that showed inequality. Like I said, it was a try. We had tired brains.
Woohoo!
Okay, here is our beautiful cartoon. It's about gender equality and that gender is no longer a binary and the law must reflect that. And this is about being able to use whichever bathroom that you would like and that everyone should sit down.
So ours is about racial inequality within the justice. Ours is about racial inequality within the justice system. So it starts off with a panel of 2 black teenagers and an older white man in a city and a cop car driving by. Cop car, they say, "Is that a drug deal going on?" And then the cop approaches, gun drawn, says, and they overhear one of the children saying, "I caught Pikachu." So.
So Arlene and I did this one, and this is a reflection on an actual story from just a few days ago. One of the legal hackers who was here was pulled aside in the line for immigration and held in a room because they were coming from a country that perhaps had ties to drugs or something like that. So anyway, so we adapted that story, and we have our guy waiting in line in pink, guy or gal, I guess, waiting in line in pink. And then right here, someone saying, "Excuse me, sir, would you please step aside?" And then standing in an interrogation room saying, "So what is a legal hacker anyway?" So.
So we wanted to take a look at how technology could change access to justice. So on this side, we have defendants saying, just walking along, minding my own business. The state saying, oh, he was behaving suspiciously. Judge, I credit the state, guilty. Introduction of body cams into policing. Same sort of frontispiece. Go to the tape, credit the individual, innocent.
Someone move the mic over to in front of her.
But doesn't have access to information or resources or in some cases legal assistance. So he's dreaming about a computer through which he could access legal services or just general legal information to assist him in understanding his charges and then hopefully, having a just solution to the case.
Forgive the artwork. We sort of morphed, I guess, 2 concepts. One of the prospect of equality or inequality, as well as the dissemination of all of the data components and sort of interchanging and sharing in the blockchain concept. So here we have many different types of race, creeds, religions, sexual orientation, basically the entire gambit people all coming together into this sort of funnel, into kind of a composite and the blockchain elementation of assimilation of all of their thoughts and processes in a true collaborative environment.
Some really interesting ideas, and I hope that this brought out the child or the creative person in you. Thank you so much for your time, and I really, really enjoyed looking at your presentations and visuals. Thank you.
Okay. I think so. Because we're a little bit behind on time, we want to stay on schedule, or at least get out on time so we can get to dinner. We're going to move right into hacking law schools, and we have first Erica.